How do defense lawyers cross-examine expert witnesses? Imagine sitting in a courtroom and hearing an expert testify that the evidence points straight to guilt. Now, picture a defense lawyer stepping up to challenge that expert. How do they do it? Let's break it down. Defense lawyers start their work long before the trial begins, often during depositions. They ask the expert specific questions about their opinions, the facts they relying on, and the assumptions they make. This helps the defense create a record they can use later. If the expert changes their story or gives inconsistent answers, the lawyer can point it out during the trial. For example, they might ask, "Other than the opinions you shared today, do you have any other opinions you plan to give at trial?" This question helps catch any surprises or shifts in the expert's testimony. Before cross-examining, defense lawyers set clear goals. They decide what facts they want the jury to hear and how they want to challenge the expert's credibility. Every question they ask must serve a purpose. They stick to questions they already know the answers to, which keeps control of the conversation. This way, they can steer the expert into giving answers that support the defense case. A key part of their strategy is attacking the expert's qualifications. If the defense can show the expert lacks certain certifications or training, their credibility drops. They might also highlight past inconsistent statements the expert made in other cases. If the expert previously gave different conclusions under similar circumstances, that can be used to weaken their current testimony. The defense can also question whether the expert has any bias or interest in the case, which might influence their opinions. When questioning, defense lawyers use leading questions that suggest the answer they want. Instead of asking open-ended questions, they ask about facts that the witness can confirm. For example, rather than asking if something was heavy, they ask if the expert observed that it was heavy based on their own actions or measurements. This method helps lock the witness into a specific answer. Repeating facts and weaving previous admissions into new questions builds a solid foundation for later impeachment if needed. As the witness responds, the lawyer watches for evasiveness or hesitation. They politely interrupt if the witness avoids answering and reminded them of the question. Using body language like raising a hand or shaking the head can reinforce the message. If the witness continues to be uncooperative, the lawyer can ask the judge to instruct them to answer directly. The lawyer also assesses how honest or nervous the expert appears. If the expert seems unsure or tries to exaggerate, the lawyer adjusts their approach. They may challenge the expert's methodology, pointing out flaws or inconsistencies with recognized scientific standards. They might ask about how thoroughly the expert investigated the case or if they overlooked important facts. This exposes weaknesses in the expert's analysis. Throughout cross-examination, the defense keeps the jury guessing by not revealing their main points too early. They start with simple questions and gradually build toward their key arguments. They aim to show the jury that the expert's testimony is unreliable or inconsistent. If the expert appears hesitant or defensive, that can make the jury question their credibility. In criminal cases, cross-examining expert witnesses is a powerful tool. It can reveal weaknesses in the prosecution's evidence, highlight gaps in their investigation, and create reasonable doubt. By carefully controlling the questions and responses, defense lawyers can make the expert's testimony less convincing and more vulnerable to challenge. The secret lies in thorough preparation, strategic questioning, and staying flexible during the process. When done well, it can significantly influence the case's outcome.